Can a foreigner lose his home in the Philippines? Can a foreigner lose his home in the Philippines? Hi, I'm Rob, co-author of the book Fly Me to the Philippines, #1 bestseller on Amazon in Philippines travel. Imagine yourself in front of a small, colorful house or one under construction on a sunny Philippines mountaintop island. A foreign husband and his Filipino wife have built a life together. On our YouTube channel, we've often talked about real estate, purchasing land, building a house. And I've mentioned many of my good friends here in the Philippines have purchased homes for their girlfriends or wives. And people write in the comment field aggressively, "It's not your house." Just this week, when we did an update on building this house, one of our subscribers said, "Stop saying our house, stop saying your house, it's not your house." Well, there's something very important we want to talk about today. Unlike most Western countries, here in the Philippines, title to the land and the community property is separated. Very unusual. In the West, you buy the house, you get the land and the house, one title. Here, you can title the structure in the community property or in your own name if you have a prenuptial, or you could buy the house, rent the house, but the land can only be owned by a Filipino. We're going to talk about that today and what that means and how that might be different. I've lived here for almost 3 years, and I was watching the Rafi Tulfo show. Rafi Tulfo is a senator, and he interviews expats who've been scammed quite often. He has other content, but one of the men, the woman sold the house and land right out from under him, and he was hoping to have the wrong righted. And there was an attorney on the show, and he said, well, there's no problem here. She can't sell the house. She doesn't own the house outright. You're married. It's community property. And if she sells the house without your knowledge and agreement, you can negate the contract that she executed without your permission. Let's talk a little bit more about that. A foreign husband and his Filipino wife have built a life together here in the Philippines. Because the Filipino Constitution restricts foreigners from owning land, the title to the land is in the wife's name or the girlfriend's name only. The husband begins to worry. What happens if she sells the property without his consent? Could he lose his home and the investment he has poured into their house? This episode explores that question through Philippine law, case histories, and practical safeguards. A quick disclaimer. This isn't legal advice. It's a research-based guide meant to help you understand the rules and to point you towards professional help. Throughout this episode, you'll see citations that let you verify the facts yourself. Also, despite rumors of a Marriage Act of 2010, property relationships in the Philippines are governed primarily by the Family Code of 1987 and the Constitution. There is no 2010 statute radically changing conjugal property rules. Setting the stage, a love story and a land purchase. To make our exploration concrete, let's follow a fictional couple. Let's call him Rob, is a foreigner who marries Maria, a Filipina from a rural province. They use their combined savings to buy a parcel of island land from Maria's cousin. Because of constitutional restrictions, the title is placed solely in Maria's name. Rob pays for the material to build their dream home and contributes to improvements on the property. Years later, Maria's relatives suggest selling the property. Rob hesitates. He fears that if Maria sells without his consent, he could lose his home. How much truth is there to these stories? The answer begins with constitutional rules on land ownership. The Constitution baseline: foreign ownership of land. The Philippines Constitution strictly limits land ownership to Filipinos and corporations or associations controlled by Filipinos. Article 12, Section 7 provides that only Filipino citizens may own land. Foreigners cannot hold land in their own names, and attempts to buy land through a Filipino spouse are treated as donations or dummy arrangements. The law does not recognize secret trusts or agreements where the Filipino spouse acts as a straw buyer or front. Courts view these as circumventions of the Constitution. One significant exception is hereditary succession. A foreign spouse may inherit land from a Filipino spouse through intestate succession. If the Filipino spouse dies without a will and no other heirs, the foreigner may receive the land, though they may need to sell it to comply with constitutional limits. Testamentary succession, however, remains off limits. The Supreme Court has ruled that devising land to a foreigner via will is unconstitutional. Other exceptions include ownership by former Filipinos under limited conditions and indirect ownership through corporations, where foreigners may own up to 40% of the equity. Foreigners can own improvements on the land, even though they cannot hold the land itself. Lexology notes that while land ownership is reserved for Filipinos, foreign nationals may hold full ownership of buildings, equipment, and other improvements situated on the land. A foreigner may have a separate title to the house and register a tax declaration evidencing ownership. Foreigners may also acquire condominium units subject to the 40% foreign ownership cap, but they can't own on the ground floor, or lease land for long periods of time. Now, let me just say right here that people talk all the time about leasing land for 25 years. The reality is it's very, very hard to find anybody who will lease land for more than 10 years. And even that is really difficult. So who in their right mind would lease land for 25 years? These rules explain why Rob's name could not appear on the land title, but could appear on documents relating to the improvements, the house. Now, buildings versus land. The house is not land. Philippine law distinguishes land from improvements. While the civil law principle of accession usually makes buildings part of the land, the Constitution's ban on foreign land ownership creates an exception. A foreign spouse may own the house and other improvements, even though the land remains Filipino. Lexology notes that 100% ownership of improvements may be titled in favor of a foreign national. Lawyers' guides emphasize that foreigners cannot own land but may own the house and must keep meticulous records, construction contract, tax declarations, and receipts to prove the house is separate property. Otherwise, courts will presume that the house follows the land, especially in succession or marital disputes. Philippine property regimes, marital property. Under the family code establishes 3 property regimes: absolute community of property, ACP, conjugal partnership of gains, CPG, and separation of property. ACP is the default for marriages on or after the 3rd of August 1988 without a prenuptial agreement. Property owned at the time of marriage and acquired thereafter, except for certain exclusive items, becomes community property. The concept is that spouses form one estate. Earnings and property become part of the community. CPG applies to marriages before that date or when spouses expressly adopt it. Under CPG, each spouse retains ownership of exclusive property such as assets owned before marriage or acquired by donation. But items and income earned after the marriage form the partnership. In both regimes, the property classifications can be complex. Commingling funds or using exclusive property to acquire assets may convert those assets into community property. Separation of property arises only through valid prenuptial agreements or by court order. It allows each spouse to own, manage, and dispose of property independently. Separation of property is particularly attractive to foreign spouses because it avoids pooling assets that could inadvertently become community property. The property rights article emphasizes that a foreign fiancé who wants to keep premarital assets separate should insist on a prenuptial agreement. The prenup must be in a public instrument and registered with the civil registry and the registry of deeds. Otherwise, it does not bind third parties. Identifying which regime applies requires looking at the date of marriage and any prenuptial agreement. Without a prenup, couples married after 1988 are under ACP by default. Those married before may fall under CPG, though couples married abroad may have their intrinsic property regime governed by their national law. However, when they acquire real property located in the Philippines, Philippine law applies. Thus, any attempt to vest land ownership in the foreign spouse's name is void, even under ACP or CPG. The Constitution trumps the family code. Land in the Philippines remains the Filipino spouse's exclusive property. Exclusive property includes assets acquired before marriage by inheritance or donation, or with exclusive funds, and property can be traced. If Maria inherited the land from her parents, it remains her exclusive property, despite her marriage. However, if Rob and Maria use community funds to pay the mortgage on a condominium, that condo may become community property. Understanding these nuances helps Rob know when his consent is required and what his share might be upon dissolution. In practice, spouses can accidentally convert exclusive property into community property by commingling funds. For example, using community income to improve a house that was originally exclusive may make the house part of the community, while using exclusive inheritance to buy a car can keep the car outside the marital community. Courts look at the source of funds and intent when classifying assets and proper documentation. Receipts, loan agreements, or deeds. These help maintain clarity. Couples who want to prevent accidental conversion should keep detailed, meticulous records and, if necessary, execute a written deed clarifying the property's character. Consent rules, Article 96 and 124, and the family home. Articles 96 for ACP and 124 for CPG require spouses to act together when disposing of marital community property or conjugal property. Without written consent from both parties, either by signing the deed or by executing a notarized special power of attorney, transactions such as sales, mortgages, or long-term leases are void until ratified. Courts may authorize a transaction if one spouse's absence is unjustified and the sale clearly benefits the family. The family home has additional safeguards. Sale, mortgage, or lease of the residence requires the signatures of both spouses, and sometimes the consent of adult beneficiaries. Recent Supreme Court cases from Abalos, Lubrico, and Cabatog to Alexander v. Spouses Escalona emphasize that failure to obtain spousal consent makes a sale void, that registration cannot cure this defect, and that ratification only validates the sale moving forward. Good faith purchasers cannot hide behind a Torrens title when the underlying deed is void. The practical lesson for buyers is simple. Always secure both spouses' signatures or a deed duly notarized, power of attorney, before transacting. You know, I used to own a real estate brokerage, and whenever you write a real estate contract, you have to say, Joe Smith, a married man, Mary Jones, a single woman, because you can't, in America, sell the house and the land if it's community property with just one party. Remedies. What happens if a spouse sells without consent? If a spouse sells community property or conjugal property without the other's consent, the transaction is void. The aggrieved spouse may file an action to declare the sale inexistent and to cancel the buyer's title, and should annotate a fis pendens to warn potential purchasers. A criminal complaint may be filed when signatures or powers of attorney are forged. Actions to nullify a void deed do not prescribe, but actions for reconveyance may lapse 4 years from discovery. So it's really important. You have to catch it within 4 years. Pre-family code sales lacking consent were voidable and could be annulled within 10 years. Post-family code transactions are void until ratified by non-consenting spouse. Ratification occurs through a confirmatory deed or acceptance of the sale proceeds. Buyers cannot rely on the Torrens system to validate a void deed. Prompt action is essential because delays risk prescription or the property passing to an innocent purchaser. Protective strategies for foreign spouses. Given the constitutional ban on land ownership by foreigners, foreign spouses must rely on lawful strategies to protect their investments. The goal is to ensure the foreign spouse's rights are recognized, that unauthorized sales can be stopped, and that contributions are documented. Below are strategies distilled from legal commentaries and case law. Ensure the title reflects marital status. The transfer certificate of title should state that the Filipino spouse is married to the foreign spouse. This alerts buyers that a spouse's consent is needed and required to prevent the Filipino spouse from posing as a single person. Register real rights that travel with the land. A long-term lease, usufruct, or mortgage in favor of the foreign spouse can be registered with the Registry of Deeds. A lease gives the foreign spouse the right to occupy the property, renewable for another 25 years. A usufruct allows the spouse to use and enjoy the property and take the fruits, and a mortgage creates a lien. Any sale of the land must respect those registered rights. Without your release or termination, the buyer cannot obtain a clean title. Annotate consent requirements and prenuptial agreements if the spouses sign a prenuptial, requiring both signatures to dispose of property. It should be annotated on the land title and recorded with the civil registry, even if the marriage is under separation of property. Annotation ensures that third parties are bound. Spouses can also annotate a declaration of family home to alert buyers that special consent rules apply. Control the owner's duplicate title and sale proceeds. Keep the owner's duplicate title in a secure place, such as a bank vault, under dual control, so your spouse cannot easily register a sale. When selling property, use an escrow arrangement that releases proceeds only upon both spouses' written consent. These measures add practical hurdles to unauthorized sales. Document the house separately. Register a tax declaration or deed of sale for the house in the foreigner spouse's name. Keep receipts, bank records, and photographs of construction expenses. Evidence of contributions helps prove that the house is indeed separate property, and you can be claimed or moved if the land is sold or transferred. Use prenuptial agreements wisely. A prenup can opt for separation of property, preventing the foreign spouse's assets from becoming community property. It can also stipulate that certain assets require both spouses' consent for disposition. A prenup must be notarized and registered to bind third parties. Avoid dummy or straw man arrangements and illegal trusts. The Anti-Dummy Act prohibits schemes that give foreigners beneficial control of land through dummy corporations or dummy instruments or hidden trusts. Do not buy land in your spouse's name with a secret agreement that you will later claim. Courts will treat your money as a donation and the arrangement as void. If you want to invest in real estate lawfully, consider owning a condominium, investing through a corporation with up to 40% foreign equity, or registering a long-term lease. Beyond registration rights and prenups, spouses and buyers must exercise due diligence. Inspect the title for annotations of marriage or a prenuptial agreement. Secure copies of the marriage certificate and any special powers of attorney, and ensure that notarized powers are specific. Do not assume property is exclusively without a registered prenup. The law presumes community property ownership. Consulting a Philippines attorney before paying any money helps ensure that documents comply with statutory formality and will withstand scrutiny. These strategies are proactive ways to protect your rights. They require paperwork and sometimes legal fees, but they are far less costly than having to litigate a void sale. Tax and regulatory consideration. Because the law treats a foreigner's contribution towards land bought in the Filipino spouse's name as a donation, the Bureau of Internal Revenue imposes donor's tax, currently 6%. I had to read that, and I apologize. I think you could tell I was reading. Behind me is a house that I am building in the mountains. It's really not a major expense. The land is in Chrissy's name, my wife. The house is community property. The lawnmower is community property. The truck, the blue truck in the background, it was so simple to title it in Chrissy's name and have her go down and do the registration. But it's actually community property because the funds used to buy it was community funds. And that's how the law works here. And if you are careful and you have a prenup, or if you are very careful in how you document how community funds were used to pay for things, it is against the law for your Filipino spouse to dispose of this property. So it's true, you cannot own land. You can own a condo, and you can own 40% of a corporation that owns land, and you can own 40% of a business, but you cannot own property. But your wife, if you're married, is not allowed to sell the property out from under you. The property on the property, not the land. Here in the Philippines, you can title property such as houses and improvements separately. So for all those people who always write in and tell me, don't call it your house, don't call it our house, I felt compelled to make this video. I apologize, it was a little dry and legalistic. Again, don't take this as legal advice. Go see a Philippine attorney, go get your own legal advice. But just so you know, for all these expats here who are buying their Filipina houses, their Filipino wives' houses, they do have half, at minimum of half, ownership of the house itself. And it can be titled separately, and you can pay taxes on it separately. And many of the men have initiated prenuptial agreements, and they might own all of the house, or they might have a lease if they could find anybody crazy enough to lease for 25 years. So when it comes to retiring in the Philippines, Philippine property, it's Rob from Fly Me to the Philippines. Chrissy will be back next week. Thanks again.